Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to Episode 80 of This Week in FCPA for the weekend in December 22nd, 2017, the holiday edition. In this episode, Jay Rosen and I return for a wide-ranging discussion of some of the top compliance and ethics-related stories of the past week, including the guilty plea by a former Embraer employee for his role in bribery in Saudi Arabia, the list of Delavois, lawyers who wrote an article for the New York University Compliance and Enforcement blog entitled Oral Downloads of Interview Memorandum to Government Regulators Waive Work Product Protection. A very significant case around work product and attorney-client privilege. A judge in Italy has ordered ENI to stand criminal trial for their alleged role in a massive bribery scandal in Nigeria. The German company Bilfinger seeks a comeback after a disastrous bribery and corruption scandal and sustaining an FCPA violation. We discussed Henry Cutter's report in the Wall Street Journal Risk and Compliance Journal. Sam Rubenfeld has an article about the Magnitsky Act and how compliance with it is easy, also in the Wall Street Journal Risk and Compliance Journal. Sam has a second article about McEachern, a supervisory special agent in the Washington, D.C. field office for the FBI's International Corruption Unit, announcing his retirement and moving over to the managing directorship at Exiger in Washington, D.C. We take a look at the conviction in the FIFA conspiracy trial of two of the three defendants. Jay Rosen reports on his weekend report. I conclude my monthly series on 1 month to a more effective compliance program, the December edition of 1 month to better written standards. Mike Volkov has a new ebook out entitled Pointing the Finger, How Corporate Boards Are Dodging Accountability and What CCOs Can Do About It. And finally, we announced an award by the State Bar of Texas for a top 10 posting this week of one of our podcasts of the podcast series, May the Podcast Be With You, the intersection of Star Wars and compliance. All 5 episodes are up now. This is Tom Fox. I hope you and your family have a most joyous holiday season. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, the Compliance Evangelist, back again for another episode of This Week in FCPA. This week we're on episode 80 for the week ending December 22, 2017, the holiday edition. As always, I am joined by my co-host and cohort, Jay Rosen. Jay, welcome.
Happy holidays, Tom.
Well, Jay, it's 79 degrees here today, so I'm going to say greetings from sunny Houston.
Awesome. I'm going to say greetings from the MASH unit as the M&M twins have been struggling with the flu all week, but we're hoping to get them out of the house and maybe even get them out to see the new Star Wars movies. So fingers crossed.
Well, we'll keep that crossed. So, Jay, we had actually a fairly interesting week in the compliance and ethics front, so maybe we can just jump right into it. We had a very, significant FCPA guilty plea this week. A former sales executive of Embraer pled guilty Thursday in federal court in New York to bribing a foreign official in exchange for helping to sell jets to Saudi Aramco. As many of our listeners will recall, Embraer settled last year with literally a worldwide bribery scheme to sell contracts for jets, one of which was to Saudi Arabia. Saudi Arabia paid the Brazilian aircraft maker Embraer paid $205 million to the DOJ and SEC back in 2016 to resolve FCPA violations, admitting bribing officials in Saudi Arabia, the Dominican Republic, and Mozambique. The bribe paid here in Saudi Arabia, was $1.5 million, and for that, Embraer was awarded a contract for $93 million for the purchase of 3 aircraft. The bribes were disguised as commissions to a South African company that was partly owned by the friends of the Embraer employee, a fellow named Colin Stephen, a UK citizen living in the United Arab Emirates. He was convicted of, or rather pled guilty to, 1 count of violating the FCPA and 1 count of conspiracy to violate the FCPA. I would say it's really not surprising, Jay, given the breadth and scope of the Embraer FCPA enforcement action, that we would begin to get some guilty pleas and individual enforcement actions. But it certainly follows what the DOJ has communicated to us literally since the Yates memo, that there would be an increase in the DOJ looking at individuals, really on a straight line almost to the announcement last month by Rod Rosenstein about the new FCPA corporate enforcement policy. So more fallout from the Embraer case. I would expect that we could very well see additional guilty pleas out of this case, and guilty pleas literally up until the end of 2017.
I think you're right on target there, and I believe with everything you're saying about the individual prosecutions. Now, we'll ask you to put on your lawyer hat and tell us about this interesting case with oral downloads and what happened with Morgan Lewis.
Okay, well, first of all, it is my legal hat. It's not my Linda Lovelace fan club hat. So just let's note that for the record on oral downloads. The article was in the New York University Compliance and Enforcement blog, and it was a really interesting article, and I would commend it to every compliance practitioner, in-house, private practice, those of you who are also known as Mr. Monitors. It's incredibly important for several reasons, one of which is the list of authors. And it is 9 or 10 co-authors, but two of which are Andrew Serezny and Kara Brockmeyer. And Andrew Serezny, in 2000 up until 2016, was the head of enforcement for the SEC, and of course, Kara Brockmeyer retired last April from the head of the FCPA unit on the SEC. So we have some very distinguished and heavy hitters writing this article. But it discusses a decision made by a magistrate court around disclosures made by outside counsel after an FCPA investigation to the SEC. And it involved the General Cable case. General Cable settled their FCPA action back in the winter of 2016. And one of the greatest year in FCPA enforcement actions ever cases. And it had a lot of interesting points, but this is really a follow-on to that. It's a situation where the SEC has brought enforcement actions against two of the General Cable employees regarding counting errors in their Brazilian subsidiary that was utilized to hide or disguise corrupt payments. And it involves the firm's outside counsel, Morgan Lewis. Morgan Lewis did an investigation, and they made oral presentations to the SEC, and I would probably note the DOJ as well, in the course of cooperating in the FCPA investigation. The court, the individuals who the SEC has brought civil actions against, had sought production of the law firm's statements regarding the interviews and their work papers. And the court, Morgan Lewis objected, claiming attorney-client privilege, but the court held that because there were oral briefings to the SEC, that constituted sufficiently detailed summary so that it was the functional equivalent of turning over an interview memoranda. And as such, that was a waiver of the attorney-client privilege. So this is pretty significant for several reasons, but most importantly from the attorney-client privilege perspective, which is that if your law firm is going to make a presentation to the DOJ or SEC, that information, not only the information they make, which would probably be in the forms of facts, but any interview memorandum they have prepared is also going to be discoverable. And so the authors note in the paper that this dilemma is even more stark with a recently announced revised policy on corporate enforcement of the FCPA, so that because companies and the U.S. Attorney's Manual incentivizes cooperation with DOJ investigators. This is going to probably put more pressure on that component of it. So the court did not require that the lawyer's notes and impressions, mental impressions or legal impressions of the interviews be turned over. That's covered under a separate privilege doctrine called the work product doctrine. But for the attorney-client privilege, if you make a disclosure to the Department of Justice of facts which you uncover in your investigation, this could very well waive the entire privilege around how you obtain those facts in any interview memorandum. And Jay, I don't quite know what your practice may have been, but my practice was I always took notes at a interview simply for my own recollection. I always prepared a memorandum based upon my notes. In the FCPA investigations I've done, I have not done or had the interview transcribed by a court reporter, but I can certainly see that as well. So this is one we're going to have to watch. The authors say that this is a very troubling decision for them, but given the DOJ's starkness in terms of what they expect in terms of cooperation now, companies may instruct their outside counsel to make these disclosures and put the privilege in play.
So I'm going to take a non-legal stab at this, but when I read the article, my takeaway was that if you were less specific in your oral information that you would be imparting to the SEC, that at that point you would preserve more of your original privilege. Is that a correct read or not?
Well, it was an argument that was discussed, but Morgan Lewis made that argument to the court, and the court said that the briefings were sufficiently detailed so that they were really the functional equivalent of interview memorandum. But on the practical side, Jay, while I agree with your reading of the article, I don't know how you would essentially make an oral argument that's so vague as to be meaningful for the purpose you're there for, which is to persuade the government that you are extraordinarily cooperating and still be able to preserve the privilege. I think you've got to be pretty specific with the government in terms of turning over facts. And I think the authors really point that out at the end, that this is a situation where companies are going to have to make could be quite of a painful call, because if you waive the privilege here with the SEC and or the DOJ, that privilege is waived for all parties, including here former employees of General Cable who are now being sued individually. It could be waived in shareholder derivative actions. It could be waived in anti-competitive action by competitors or other actions. So it's going to be a kind of a tricky road to navigate, I think.
Yeah, it sounds like something that bears watching that we're going to see coming up into the new year. Now we switch over and we check in with a German company, Bilfinger, which is an industrial services company, and they have spent about €100 million to get their compliance program in order. And this is an interview that our good friend Henry Cutter at Risk and Compliance Journal did at the Wall Street Journal. And the interview is with Michael Bernhardt, an executive board member who handles HR and safety, and Olaf Schneider, who's the general counsel. And they're discussing how Bilfinger initially got into trouble and what they're doing to get out of it. And right now they're really have kind of come in and cleaned house. Initially, the DPA that they were under was supposed to end early, but it got pushed out, and they're anticipating that it's going to end in 2018 during the next year. And some of the things that are mentioned in the article, which we've talked about quite often about best practices, is that some of the executives' compensation is going to be partly based on how well they drive initiatives in terms of their ethics and compliance, and they'll be using measures in terms of how many trainings, how many workshops, and how much information is communicated to their employees. So that definitely seems to be a step in the right direction. And they really seem to have gotten the religion now, and they are really not going to be happy until this is pushed out into the entire organization. So from the ethics and compliance perspective, I think we're happy to see that they've made appropriate steps to move forward, and hopefully this will keep them from becoming a recidivist. Anything you wanted to add on that one, Tom?
Yeah, there was one thing that I found really interesting in the article, Jay. And in addition to all the points you raised, Henry asked a question, and I'll just read the Q&A because I found it very powerful. Question from Henry Cutter. Bilfinger hired a lot of people from outside for top roles as it underwent its compliance overhaul. Why did you have to hire externally? And Mr. Barnhart answered, to get the networks that people normally have internally destroyed, just have a fresh start. They can come up with a completely fresh mindset and don't have any networks that they have to take care of. That is a major, major thing. And I was really intrigued by that point, Jay, because that is not something that I've really heard spoken about quite really at all in any of commentary around FCPA enforcement or compliance, or really any of the commentary that you and I subscribe to. And that's the networks in a company that will facilitate corruption. Here, Bilfinger had a systemic culture of corruption within the company, and they didn't try to remedy it by simply firing a few top people. They went after the networks which facilitated that discussion, and they replaced key people. And I think this is something that the Department of Justice really should pay some significant attention to when a company comes with a remediation plan in the context of a settlement around an FCPA enforcement action. What did the company do to not only change its culture, but to destroy internal networks that may have facilitated corruption? Now, it could be a sales group in a particular territory. It can be a sales group in a product line, but it could be cross-functional. It could be a sales group. It could be internal audit. It could be your accounting and finance folks that typically are siloed. But if there's really a network which allowed this, and recorded payments, as we saw in the Embraer case, recorded payments to vendors corruptly that were inaccurate, or in the General Cable case where the Securities and Exchange Commission claims that individuals at General Cable actually misrepresented the books and records for corrupt payments. So I found that point really interesting, and that's something that I think bears further exploration. And if the Journal or the Wall Street Journal, other journalists might really explore with companies that have come out of significant FCPA violations, this point on how did you actually not change culture, but destroy the networks within an organization, the structural foundation which allow corruption to occur. So I found that point really interesting.
I'm getting a visual of them almost having to tent the company and fumigate it, knock everything out, and then start again fresh. So I think that also bears watching in the coming year.
Absolutely. So, Jay, I don't know. I know you know Sam Rubenfeld, and he's quite familiar to our listeners as a part of the Risk and Compliance Journal at the Wall Street Journal. But I have to say, one of the things that Sam is very passionate about is the Magnitsky Act. And he talks about it, he writes about it, and he had us an article up today, I think, about compliance with the Magnitsky Act. That's something that has become more to the fore, certainly under the current administration, and whether or not there was a quid pro quo by any part of the administration or its transition team to soften the Magnitsky Act. So why don't you tell us about what Sam has written about today?
Sure. So basically, the U.S. Treasury Department on Wednesday released sanctions and regulations for enforcing the Magnitsky Act, which targets Russian human rights abusers. But sanctions experts say the rules won't require any new compliance. So with this new information, it now raises to number of people who are blacklisted under the Magnitsky Act to 49 folks, according to the U.S. Treasury Department. And these basically, Sam says that it's not really going to change enforcement in terms of how you would deal with this as a company, because if you have a PEP list or any other folks who are going to come up on a sanctions list, these same people from the Magnitsky Act would also hit that thing. So, I don't think it's anything new except for the folks who are now making that list. Any thoughts on your part, Tom?
Nope. I think you hit the highlights, and it's something that not only is it a political issue here in the United States, but it's really a compliance issue. So I was very pleased that Sam took a look at it from the compliance perspective.
Okay, so now once again another article from Sam. He had a little bit of, a little bit of a news break that he came out with earlier this week on the 19th. And I know we throw around the term a lot, our good friend, but in this situation, it really is some news about a good friend, and it's George Wren McEachern, who we know of from the FBI. And over the past decade, Wren has been very visible working with the SCCE and other organizations to promote the FBI's anti-corruption agenda. And Wren was basically in charge of dealing with money laundering, kleptocracy, and antitrust cases. And a couple of years ago in 2015, when the FBI announced that they were rolling out specialized improved FCPA teams in New York, LA, and DC, Wren was definitely one of the folks there who helped them execute. So it's bittersweet to see him leave government service. He will be starting at Exiger, working as a managing director in the firm's global investigation practice, and this will begin after the new year. So I know we will still be in touch with Wren. It will be nice to have him on our side of the fence in the private sector, but we wish him well with his exciting new opportunity.
Absolutely, Jay, and I found it really interesting. He has been the public face of the FBI's International Corruption Unit for at least 2 years, a couple of years, and maybe even longer. Obviously been with the FBI quite some time. So the FBI is going to lose a very, very public person, a person who was on the speaker circuit, who talked about what the FBI did. He was very open, I thought, about talking about the numbers of investigations and how corruption investigations were moving forward. He was one of the people who really made clear, even after the new administration came into place, nothing was really changing in the trenches, certainly at the FBI. And I found it very interesting that Exiger would bring him on. Obviously, a very talented individual from the investigative perspective, but also talented as a face for Exiger, and someone who can get out and really talk about that company, what that company does, services it's going to bring. And so I'm going to be really interested to see him in the private sector. And as you said, welcome him over. So welcome.
And welcome, Wren. And Tom, I know you're a big football fan, both U.S. and global football. So why don't you share with us some breaking FIFA news?
Right. So the two of the three defendants in the federal trial in Brooklyn were found guilty. The former heads of the Paraguayan and Brazilian soccer associations were guilty of racketeering, conspiracy, and other charges, giving the government at least a partial win in a major corruption trial. It involved decades-long scheme in which sports marketing companies funneled hundreds of millions of dollars to pay bribes to 24 soccer officials. This all, of course, turns on the DOJ's operation against FIFA, which happened about 18 months ago. This is the first set of individuals going to trial. Juan Angel Naput, the former head of South American Soccer Federation CONMEBOL, and Jose Maria Marin, former head of the Brazilian Soccer Federation, were found guilty. A third individual, who I believe was from Paraguay, but I may have that wrong. There was no decision on him by the jury. So, but very big win from the DOJ's perspective. The sordidness of corruption at FIFA that came out in this trial was just, I thought, overwhelming, and they really did treat it. I don't even think medieval fiefdom fully describes how these guys enriched their own pockets literally across the globe through the world's most popular sport. So a big win for the DOJ, a big win on corruption. Hopefully this will get some of the other defendants who have pled not guilty to consider their pleas and cooperate with the government going forward. So very interesting. We'll have to wait and see about the third defendant and whether or not what the verdict will be on him. That's Manuel Burga, actually the former head of the former Peruvian Soccer Federation as well. So very interesting case. Lots went on, and we're going to have to keep an eye on this one as well.
What's happening in the podcast universe, Tom?
So in the podcast world, I'm concluding the last month of my 1 month to a more effective compliance program. In this month in December, I've been discussing written standards and a best practices compliance program. I wrap that up today and into next week. The Tom Fox and Jay Rosen joint effort, May the Podcast Be With You, on the intersection of Star Wars and compliance. I think both we would believe it's been a very big success. It premiered on December 11th. We've had 4 episodes by now. The 5th one will have posted. So, and the first episode on Star Wars A New Hope, Episode 4, and What is Risk, was awarded a top 10 post this week by the State Bar of Texas. So we've already won one award for this series, Jay. So it was a lot of fun, and I think this may be a harbinger of things you and I do, where we have a very tightly focused 5-day or perhaps even longer podcast series. I should also note that May the Podcast Be With You was very generously sponsored by Affiliated Monitors. Jay, I believe we do have a very big announcement that Jay Rosen has actually written a Jay Rosen Weekend Report. Before we get to that, I do want to say that Mike Volkov has published a new ebook, Pointing the Finger: How Corporate Boards Are Dodging Accountability and What CCOs Can Do About It. It was released this week by Corporate Compliance Insights. For those of you who don't know, Mike Volkov is one of the hardest working guys in compliance. It's a great book. So take a look at it. I've downloaded it, and it's got lots of bite-sized information that you've come to expect from Mike. So with that, we're going to have a virtual drum roll, and we're going to ask, is there a Jay Rosen Weekend Report?
Indeed there is, Tom. It's entitled LinkedIn, What's in a Number, and Are You More Than Just a Link Collector? So my own internal odometer on number of LinkedIn connections kicked over from a 99 into a new realm that I'm filling out. And it made me start thinking about, how I've used LinkedIn in the past, how I've gone from having, less than 300 to 500 folks back in 2004, and now having several thousand people who I'm linked in. And it's just a set of, I think, best practices, how I think people should use the tool, and how, in fact, LinkedIn was one of the things that brought you and I together, because I started reading your stuff on the internet. I reached out to you. You were very generous, and then you've really helped propel me forward in social media and in the area which we discuss every week. The FCPA ethics and compliance. So this is kind of like a swan song to the end of the year, and some hopeful ideas about how people can get the best out of using social media and connecting with like-minded folks.
So Jay, I guess I did want to ask, I believe I'm correct in, or am I correct in believing that the celebration of Hanukkah has concluded?
Yes, the last day of Hanukkah was this past Wednesday.
And so did the Rosen household have its annual Hanukkah celebration for M&M and crew?
We did. It was a little bit, as I said, dampened by the flu that the girls were having. But we had Rebecca's mom came in from D.C., and my sister and my niece came in from the East Coast. So we had a lot of fun. We played some dreidel. We had some traditional jelly donuts, and now we're ready to celebrate Christmas the way that we always do, which is going to see some movies on Christmas Day and getting some Chinese food. So what are your plans for the holidays, Tom?
So that sounds like actually the Christmas Day I want. My wife and I are going to England. We're going to the old country, back to the old country to see Clan Story and my wife's 33 cousins. So it should be a rollicking good time. And we are, on Christmas Day, we're going to have English Christmas dinner at a pub. So that's going to be interesting. Perhaps I can report on that at some future podcast. But heading over to the old country and looking forward to seeing my in-laws and the family and a lot of other people. So, Jay, with that, you want to take us home from this holiday edition?
Sure. So on behalf of Tom Fox, the compliance evangelist, and myself, Jay Rosen, Mr. Monitor, we'd like to thank you not only for joining us this week, but joining us throughout the year. And this has been the holiday edition of This Week in FCPA for the week ending December 22nd. Wishing you all happy holidays and a wonderful new year.
This is Tom Fox again. I'd like to thank you for listening to this episode, the special holiday edition of This Week in FCPA. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jay at jrosen@affiliatedmonitors.com. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and also help get the word out about the only weekly roundup of compliance, ethics, and compliance-related stories. Once again, thank you for listening to this episode of This Week in FCPA. This Week in FCPA is a part of the Compliance Podcast Network.